Good morning, my name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today with the Labor Attorney Jung Bong-soo, we will cover the Article 95 of the Labor Standards Act, which is the limitation on punitive provisions. So this article terminology is a bit maybe difficult to translate. So could you explain the terminology, please?
Hello, how are you today? This is Bong-soo Jung, Korean Labor Attorney. Today I'd like to talk about some Article 95 of the Labor Standards Act, limitation on punitive provisions. So this article shows when employer reduce salary due to the employee's wrongdoing or some violation of company regulation, then employer can reduce their salary up to 50% of their average wage per day. In a monthly, they can reduce up to 10%. So this is a regulation. So this is a typical example for some kind of punitive action. But the other way, like kind of termination or like a company should include such a disciplinary action in their rules of employment. In that case, company, even though they introduce many different types of punitive action, but when those items are violate labor standard act, then they are null and void, and in that case, labor standards applied. So especially Article 95, some deduction of salary can be accepted only 10% of monthly salary. So this 10% means if they decide to punish employee with a wage reduction for 2 months period, then it is possible to deduct up to 5% for each month for 2 months period. So in total, it will be 10 months. 10% of their 1 month salary. So, but in case of public employees, like government employees, they have a different application. They, like in the case of wage reduction for punitive provision, they don't have any limit for the wage reduction. But normal workers, they should follow this regulation. Yeah.
I see. So from the employer's point of view, when does normally this employer give a reduction of the wages? It's like a punishment to the staff.
Yeah.
In case of wrongdoing.
Yeah. So employer have the authority or some right to punish employee when employee violate company regulation. So they need to control their organization with the disciplinary action. So if their punishment is more than their violation, or they abuse their like managerial power or disciplinary action power, then that is regarded as a kind of violation of labor law. Then employee can apply for remedy application to Labor Commission according to the Article 28. So this article showed the limitation on the punitive action and that employer can take. Yeah.
I see. So in case of employer decide to make a punishment to the employee, does he just make a reduction of the wage by themselves, or they need to discuss with the employee to accept the reduction?
So yeah, I think it's a good question. So how to discipline employee? So usually by legal requirement by Labor Standards Act, employer should introduce disciplinary action process in their rules of employment. So rules of employment contain those disciplinary action process. So some company, they decide to the discipline employee, they must have some discipline action committee first, and in the committee they make a decision for discipline action. But some company, they don't have such a discipline action, disciplinary the meeting process. Then company can decide their discipline action unilaterally. But in such a case, such a discipline action can be regarded as abusing of managerial rights. So it's better to have such a some collective decision-making process through disciplinary action committee. Yeah.
I see. Very good introduction and explanation. So, do you want to add any additional comment about this article 95?
Yeah, Korean labor law, it is said it's very strict to fire people, but company follow the right procedure, giving another opportunity. Korean labor law is very not strict for employers. So the important thing is when company give us some second opportunity. So in Korea, disciplinary action, there are types of, based on severity of punishment. The severity of violation, there is types of punishment, right punishment and also severe punishment. Severe punishment can be a disciplinary dismissal, or right punishment is written disciplinary, like written notice for disciplinary action or wage reduction. So it can be a right punishment. So like deciding right punishment is like giving another opportunity, so employee can correct their wrongdoing in the near future. So I think when employer consider this the provision, then they'll avoid any labor dispute. That means company should consider the severity of violation, then they decide some level of punishment. Yeah.
I see. Thank you very much for your comment.
Okay, thank you for watching. Bye bye.